Hello, everyone. This is Wakaba Tessier, a partner at Husch Blackwell. We are excited to give today's presentation on hot topics in education and healthcare settings with a focus on research compliance. Now, we know that we have a wide range of audiences today, people who don't come across research issues very often to those that do this every day. So we will cover the basics while offering information that is valuable to the seasoned veterans. Our education and healthcare groups at Husch Blackwell have been called on to help with this topic within our combined academic medical centers team. We are pleased to offer our first combined webinar within the series. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Indiana, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Again, the presenters today are me, Wakaba Tessier, and joining me is Pete Land. I concentrate my practice in healthcare regulatory compliance issues, so I will present on issues that I have seen with respect to our healthcare clients, while my co-presenter, Pete Land, will present on issues that he has seen from his education clients. Pete concentrates his practice on serving private and public sector higher education institutions and academic medical centers in a wide array of litigation and counseling matters. He also advocates on behalf of education institutions in court and agency proceedings, mediations, and arbitrations. So let us get started then with the webinar. Thanks again for attending. First is the agenda. I'm going to talk a little bit about the common rule and then the compliance pitfalls and enforcement actions with human subjects. Pete Land will then take over and talk about research noncompliance and research misconduct. So I wanted to make sure to touch on the updated common rule, and we will go through this by talking about the who, why, when, what, and where of the updated common rule. So first is the who. A quick history on the who. This is also discussed in the executive summary of the final rule as well if you're interested in further reading, but the gist of it is as follows. The Department of Health, Education, and Welfare first published regulations for the protection of human subjects in 1974, and the Department of Health and Human Services, which we will call HHS in this webinar, revised them in the early 1980s. During the 80s, HHS began a process that eventually led to the adoption of a revised version of the regulations by 15 U.S. federal departments and agencies in 1991. The purpose of this effort was to promote uniformity, understanding, and compliance with human subject protections, as well as to create a uniform body of regulations across federal departments and agencies. This uniform rule is what we now know as the common rule. So why was the common rule updated? The final rule cites several reasons for the amendments to the common rule, and these are some of them. Until the final rule came out, the common rule had not been amended since 2005. the volume and landscape of research involving human subjects have changed considerably. There's also diversification of the types of studies conducted, and there's growing use of electronic health data and other digital records. And really, generally, there's just different technology out there. And so essentially, the common rule had to be updated in order to better align with these changes. When? The final changes to the common rule were published on January 19, 2017, but the general compliance effective date was pushed back from July 19, 2018 to January 21, 2019. But on July 20, 2018, HHS issued guidance documents with respect to the three, what they call the burden-reducing provisions, and gave the option to institutions to implement these provisions, and these provisions only during the delay period, which is between July 19, 2018 and January 21, 2019. So let's talk about the what, and before we dive into sort of the general changes to the common rule, I think we need to talk about these burden-reducing provisions. For any ongoing study prior to January 21, 2019, the default is to apply the old common rule. So that when I say old, it's actually the current common rule. But institutions have the option of applying the following three provisions related to the revised common rule. The first is to use the revised definition of research, which excludes certain categories from the definition of research. The second is to remove the requirement for continuing reviews for certain categories of research. And then the third is to remove the requirement for institutional review boards to review grant applications related to the research. Guidance documents related to these burden-reducing provisions were published by HHS, and we have links to those on the WHERE slide that we'll go over in a little bit. But they're also placed in your resource folder if you wanted to take a look during this webinar. But there are things to keep in mind if you do decide to implement these provisions earlier than the general compliance period. There certainly needs to be documentation about why certain research studies were able to take advantage of these burden-reducing provisions. Obviously, there should be robust documentation with respect to each study. For example, why did one study qualify for these provisions while the others didn't? When did you start taking advantage of these burden-reducing provisions? And also, if you choose to implement these provisions, they need to be implemented as a package. So the question really is it really burden-reducing for the institutions now? Because there's a lot of documentation analysis that goes into this.
So Wakaba, we have a question that's come in here. You had talked about the definition of research and that it excludes certain categories of research and that certain categories of research do not require continuing review. Can you talk about what are the certain categories of research you're referring to?
Sure, that's a really good question. Thank you for that. So how about I'm actually going to talk about the second burden-reducing provision first because that's one's a little bit more complicated. As you recall, the second burden-reducing provision is the removal of the requirement for continuing review for certain categories of research. In January, when all the common rule is implemented, the common rule will allow you to skip continuing review for three categories of research. And that is research that is eligible for expedited review, research that qualifies for limited IRB review, and research that has reached a certain point that involves data analysis or ongoing follow-up. But in the interim, so right now that's between July and January, only 1 in 3 are allowed. So 1 was research that's eligible for expedited review, and 3 is research that has reached a certain point that involves data analysis or ongoing follow-up. And what's even more complicated here is that the definition of what is research eligible for expedited review is going to change in January with the Common Rule. But for now, we have to follow the current or the old definition of research eligible for expedited review. So there's really a lot to keep track of. Now, with respect to the first burden-reducing provision, which was certain categories of research excluded from the definition of research, there's also guidance published on this on HHS, but I will touch on all four of them. These categories are scholarly and journalistic activities, public health surveillance activities, collection and analysis of information, biospecimens, or records by or for a criminal justice agency for criminal justice or investigative purposes, and authorized operational activities for national security purposes. I know this is a lot to take in, so again, on the where slide, which is coming up, I will talk about and introduce links where you can find more information on these burden-reducing provisions. But just so that the audience knows, with respect to the definition of research during the interim period, HHS has only published guidance with respect to what constitutes scholarly and journalistic activities, and not any of the other three, like the public health surveillance, the criminal justice agency stuff, and then the authorized operational activities for national security purposes. So in the guidance for scholarly and journalistic activities, OHRP talks about, and this is I think the key word, is generalizable knowledge. So if a research collects information about various individuals to draw generalizations about those people or that population, then that's considered research. But if the information gathering pertains to just one person, then that's probably not research because it's not generalizable knowledge. So I hope that answered the question a little bit better. And then let's move on from the burden-reducing provisions to sort of the more noteworthy changes of the Common Rule. And obviously, we could take an entire webinar session to talk about all of the changes to the Common Rule, but I just wanted to point out a few things. So again, there were revised definition of terms like clinical trial, human subjects, and then activities not deemed to be research, which I just touched upon. There's also new informed consent requirements. There are surprisingly certain elements that must be included, and there are additional notices that have to be included, like the possibility for commercial profit and whether research will or might include whole genome sequencing. But a little bit more about the informed consent piece. So HHS, in making these revisions, put a big emphasis on letting people make their own decisions on what they want and what's most important to them. So in order to do that, HHS set a certain standard, which is what would a reasonable person want to have in order to make an informed decision about whether to participate in a particular study. HHS also talks about how informed consent can be long and complicated, almost 20 to 35 pages or so, they said. So the key is to put the important information up front so that it's as easy as possible for the potential study participants to understand. There's also a broad consent now that researchers can obtain, and I also wanted to talk about that a little bit. The final rule expressly permits researchers to obtain broad consent for the storage, maintenance, and secondary research of identifiable biospecimens and data. If broad consent is obtained, any subsequent storage, maintenance, and secondary research uses of the individual's identifiable biospecimens and data consistent with the broad consent would not require additional consent, so long as additional conditions are met. And the final rule has laid out various elements for broad consent, and that's actually 9 elements to be exact, but I wanted to just point out a few of those. It requires a general description of the types of research that may be conducted with the identifiable private information or biospecimens. This description must include sufficient information such that a reasonable person, again, would expect that the broad consent would permit the types of research conducted. You also need a description of the identifiable private information or identifiable biospecimens that might be used in research, whether sharing of identifiable private information or identifiable biospecimens might occur, and the types of institutions or researchers that might conduct research with the private information or biospecimens. You also need a description of the period of time that the identifiable private information or biospecimens may be stored and maintained, and a description of the period of time that the private information or biospecimens may be used for research purposes. So there's that. Let's see. So let's go to where, and this is what I've been alluding to all along, which is some links that you might find helpful. These links are all included in your resource folder as well, but these slides will also be available tomorrow. So I also wanted to go through some examples of OHRP investigations and enforcement, and OHRP stands for the Office of Human Research Protection. Obviously, there are other agencies that come in and do some audits and investigation, but for purposes of this webinar, I thought that I would concentrate just on the OHRP investigations and enforcement. So as I was preparing for the webinar, I looked at the investigations that are posted on the website, and there's definitely a trend, right? There's a trend in that a little over half arise out of complaints, and the rest are OHRP-initiated investigations. And many of the investigations stem from complaints that were related to informed consent. So I'm going to provide some examples for you so you can just get kind of an illustration of some of the complaints related to informed consent work. So the first one is the complainant alleged that field interviewers were told to repeatedly call respondents, and if they gave a reason why they could not continue to participate, for example, that they were too ill or too old or caring for a dying family, which seemed like perfectly legitimate reasons, interviewers should explain to them how important they are to the study and mark down the results in the case file. Eventually, the rejected cases were handed over to someone else who would continue to call these potential subjects to attempt to get them to participate. There were no limits on how many times interviewers could call these resistant respondents, and subjects were offered gifts and increasing monetary prizes for continued participation when they expressed a desire to discontinue participation in the study. OHRP didn't like that. After a lengthy back and forth between OHRP and the institution, including a corrective action plan, where the IRB was involved and they had to come up with processes related to what it means to get a hard refusal, OHRP accepted the corrective action plan. There's another one where a complainant alleged that the research recruitment procedures did not minimize the possibility of coercion in violation of the common rule. An investigator, and one of the rules is that an investigator shall seek consent only under circumstances that provide the prospective subject or the representative sufficient opportunity to consider whether or not to participate and that minimize the possibility of coercion or undue influence. But here, according to the complainant, when the person declined to participate in the research, this person was met with physical and psychological intimidation and retaliation, including coercive confinement in a small room while collection of information occurred without her consent. So this, again, was obviously not good with respect to OHRP, and you can kind of see why. The next one is, this was actually not due to a complainant, but this was essentially part of OHRP's audit process, but they call them not-for-cause evaluations. OHRP, after reviewing various policies, procedures, and consents, found that the verbal informed consent pre-screening processes reviewed and approved for multiple protocols did not include all required elements of informed consent, such as the purpose of the research, the procedures and risks of the screening, how confidentiality was maintained, and whom to contact with questions regarding the research and subjects' rights. The institution, again, had to go back and forth with OHRP and change the script, and the script actually had to be approved by the OHRP. These are all obviously investigations and enforcements under the current common rule or the old common rule, but because the changes to informed consent was a big part of the new common rule or the revised common rule, you would expect that the focus of these investigations and enforcement will be on informed consent. And so just remember that these informed consents can't be coercive. It has to be concise and focused, and a reasonable person needs to be able to understand this. On the OHRP website, as I told you earlier, you can find a list of types of determinations that OHRP has made in compliance oversight activities over the last several years. The list is pretty long. There are 51 different types of possible violations that one can commit, so it's a little bit scary. But for those who dare and for those who are interested, the website is provided on this slide. But I'd like to give you some examples. So some of the examples noted on this website is research conducted without IRB approval, failure to report unanticipated problems, noncompliance, suspensions and terminations to IRBs, institutional officials, and OHRP. IRB approval without adequate information from the researcher, inadequate continuing review of the research protocol, and failure to provide a copy of the informed consent document to the subject. And I think what's interesting here is there are some enforcement actions against IRBs as well, and I know some institutions have their own IRBs, so it's definitely worth looking at.
And Wakaba, we have another question here. Maybe you could talk about whether you can give us an example of another OHRP enforcement or investigation related to one of the examples that you gave us.
Yeah, sure. So I have one that I can talk about. So HHS regulations list certain basic requirements for an IRB to approve research. When the convened IRB requests substantive clarifications or modifications regarding the protocol or informed consent, approval of IRB cannot happen, and that approval has to be deferred pending subsequent review by the convened IRB of these responsive materials. Well, OHRP went in to do an investigation, or one of those audits, right, those not-for-cause investigations. And based on the minutes that OHRP reviewed, it determined that when the convened IRB requested substantive clarifications in a particular protocol, the IRB approved the research with conditions in the absence of information that the IRB needed in order to approve the research. So one condition stated, it's unclear what the outcomes are. It's confusing what's really happening in the study. Please include a hypothesis. Please give us information. The IRB would have needed this information in order to make the determination that risks to subjects are minimized, but they went ahead and approved the study anyway. And so the corrective action included improving the accuracy of the board's determination, which was to be accomplished by retraining the IRB chair, IRB vice chairs, IRB managers, and any IRB specialists on the human research protection standards. And this training also included the development, I think, of an IRB spreadsheet with particular emphasis on the restriction that the board may grant approval with conditions. And so I think the key here with all of the enforcement actions that we've talked about really is all about documentation, whether or not you are implementing the burden reducing provisions or whether or not you think there might be an OHRP audit at some point. As long as things are documented, it seems to, I think that's probably the safest thing, because when OHRP goes in and does an an audit, they can only see what they can read. So if the documentation, like the IRB minutes, don't adequately reflect what happened and what went on, there's no way for the OHRP to know. So these, I wanted to touch a little bit on other compliance issues. These are, to be fair, separate webinar topics in and of itself, but I thought that it would be remiss if I did not touch on these issues. So the first one is billing issues. Clinical trial research billing is very complicated. You probably all know that, but the institution needs to figure out the budget for the trial, track the trial participants, medical documentation and medical necessity, services provided as part of the clinical trial, and segregate those services from the normal course of treatment, figure out what and how much to bill insurance, all of that. And there is an example that I thought I'd share with you. So this happened in 2013 at Emory University. Emory had to pay $1.5 million to settle a False Claims Act claim. The investigation conducted by the DOJ stated that providers generally are not permitted to bill Medicare for medical care and services for which the clinical trial sponsor has agreed to pay. Here, the United States and the state of Georgia alleged that Emory billed Medicare and Medicaid for services the clinical trial sponsor agreed to pay, and in some cases actually did pay, thereby resulting in Emory's being paid twice for the same service. And then there's one from the University of Alabama where they entered into a $3.39 million settlement because the government alleged, or because the university alleged to have billed Medicare for research time spent on patient care when no patients had been seen, and for clinical research trials that were also billed to the sponsor of the research grant. So again, this is a double dipping situation. Now, grant administration is also a big part of research administration, and there's just a whole bunch of rules and compliance issues. And again, this warrants a whole new webinar topic, which we're happy to address in the future, but I thought I'd give just a little bit of a flavor and an example. This is from 2016, where the DOJ and OIG announced that they had entered into a $9.5 million settlement with Columbia University for improperly seeking excessive cost recoveries in connection with federal research grants. The United States complaint alleged that from July 1st, 2003 through June 30, 2015, Columbia impermissibly applied its on-campus indirect cost instead of a much lower off-campus indirect cost rate when seeking federal reimbursement for 423 NIH grants where the research was primarily performed at the on-campus facilities owned and operated by the state of New York and New York City. The complaint further alleged that Columbia failed to disclose to NIH that it didn't actually own or operate these facilities, and Columbia didn't pay for the use of the space for most of the relevant period. Columbia agreed, and they had to enter into this costly settlement. So these are just a few things to keep in mind as in terms of research issues. Now I'm going to turn it over to my colleague Pete Land, who will talk about research noncompliance and research misconduct.
Thank you, Wakaba, and thanks to everyone for joining us today. I'm going to approach the topics of research noncompliance and research misconduct from a perspective of what to do when things go wrong, and really from a 40,000-foot view about those topics. So these discussion points are intended to be an introduction and assessment of some key topics in this area, as well as some approaches to keep in mind. And I've been involved with various complex investigations the last 10 to 15 years, and my experience in these areas the last several years have been involved and have led me to try to think back to how I thought about these issues when they were new and as they may be to many of you, so to present that kind of approach. And one idea is that when things go wrong, it's best to try to have thought through how to handle them in advance if you can, to have a plan for how to think them through, and that's really one of the main goals of my comments today. So with that in mind, I have a couple of slides that kind of are not technical but more philosophical in terms of how to approach these areas. So the first has to do with a to-do list of thinking and planning, and this is really something you can do in advance of any particular issue arising, and I think can be a really good idea. So one thing to keep in mind is to make sure you know what the substantive rules are, both the legal regulations and laws, but also particularly the policies that exist at your particular institution. They can be incredibly important, and they're expected by the federal regulating bodies in this area, and may have different requirements or additional requirements than the regulations themselves. So it's good to know that in advance. Another thing to make sure you're aware of is and think through is who can be affected by issues of research noncompliance or research misconduct. That might seem simple, but it's not in this area. There are many different constituents to consider, individual people, as well as the institution as a whole that has interests when these issues arise. That can include the accused party, maybe a whistleblower who raised the issues, administrative officers who have to address such issues, witnesses with all sorts of different experiences and perspectives. And so these issues present a complex series of personnel-related issues in addition to the science, and it's important to try to have some understanding of that early on. Another idea to try to keep in mind or learn a little bit about is who needs to be notified when these issues come up. That can include both internal notifications to various constituents within your institution, as well as required external communications to agencies involved in this area. Some such notifications are required, but there's also attention with making sure to restrain too much communication about these issues early on to try to preserve confidentiality interests, both of the facts that are under investigation and to avoid undue harm on reputational interests, both of individuals and the institution. We'll talk more about that as we move ahead. But the last issue to kind of keep in mind in your to-do list in advance is the concept that there can be public disclosures that result from these types of issues and that can have an impact on the institutional reputation. So while people doing the research tend to be the cause of such issues, the issues become much bigger than just those people or just personnel issues. And it's important to understand that, to plan for it, and to prepare other leadership in your organization for that possibility before they come to your door. Another slide here talking about how to prepare in advance has to do with who should be involved when things go wrong, who should always be involved. So the circumstances obviously vary depending on the specifics, and I'll be talking about two of them really, noncompliance and the animal care and research misconduct. But for both of those and for other issues, you need to make sure that certain people know and understand who they are. So one of those is the institutional officer who's responsible for these things on behalf of the institution. You need to know who that is, preferably have a relationship with that person and share some planning in advance of an issue arising. The institutional officer is going to be relied upon or sought by federal and state regulators. They'll look to that person, so he or she needs to be ready in advance. Another person who's always involved in these issues is the research integrity officer, the RIO. The RIO tends to be closer to the specific facts of these situations as they arise than the institutional officer, maybe leading efforts to enforce policies and ensure adherence to the rules, as well as any investigation that may need to be done. Another person who you'll want to make sure is involved is some form of legal advisor. With different institutions having a variety of numbers of people in their in-house counsel bench, it's helpful if one of them can be knowledgeable about these issues, because you're going to need a sounding board pretty early on when these issues come up to figure out how to navigate the various requirements. And the last group or people to make sure that you have some understanding of might be your monitoring or audit teams, to make sure that you know when and how to inform them that something has come up in advance. So again, it's important to understand who the team is before the crisis arises, so that when it does, you can respond on behalf of the institution quickly. So with those ideas in mind, I think we'll move on to the first topic, of substance, which has to do with research noncompliance and particularly with respect to animal welfare. I'll talk less about this issue than I will the research misconduct issue, but it's worth addressing. So, what are the rules, you might wonder, that apply most generally to animal welfare issues that come up in research noncompliance? And there are really three forms here of the major rules. They come from the Public Health Service, which is PHS, and their policy on humane care and use of laboratory animals. PHS includes NIH, the National Institute of Health. There's also a guide that can be very helpful from the National Research Council. It's the Guide for the Care and Use of Laboratory Animals, and the links are provided here and are available in the resources that Rakaba mentioned. And then there's a blue book that's mentioned here from the Department of Agriculture about Animal Welfare Act and Animal Welfare Regulations. All three of these materials have extensive references and can be very helpful to get your arms around what the issues are that apply in this area. So, boiling it down, though, in the animal welfare area and research noncompliance, what's the purpose of having the rules that you can find? And the guide explains in pretty concise terms that these rules are intended to assist institutions in caring for and using animals in ways judged to be scientifically, technically, and humanely appropriate. And that's the main goal. It seems simple, but it's important for people to understand, and it should guide what people, your researchers, your PIs do, and what the institution seeks to achieve whenever these non-compliance issues come up. And so another thought to keep in mind is why. Why do people stray from the goal of trying to treat animals in a humane and scientifically, technically sound way? Why are these rules end up being violated at times? And I think there are various pressures that scientists feel, and they're human, and people can't be perfect, even scientists who are trying to be as objective as possible. And I list some of them here. So there's the competitive environment that they operate in, and I think you can never underestimate the pressure to publish, the pressure to have meaningful research, the pressure to have research hypotheses pan out and demonstrate what people are seeking. And these people are driven, and they really have an uphill battle to try to achieve their goals, and that can lead to some pressure. There are also some pressures that come from limited resources. And with that, I mean, the animals themselves that are being subject to research, they only have so many of them at times. They need to make the most of what they have, and it could be tempting at times to try to find shortcuts or adjustments along the way that might not comply with the protocols that were approved in advance in every way, and that can lead to noncompliance. There are also some pressures from time. It's a very important commodity for everyone involved in research, PIs, graduates, students, anyone in the lab. They want to make their mark, and they want to make progress so they can move on to the next project and get more funding. And when time is a limited resource, that can lead to some bad decisions about following various protocols. So that can be a pressure. The last one is just sometimes, is just a lack of diligence. I mean, scientists tend to work hard and be very careful and objective, but sometimes they stray from that or may not follow their protocols as carefully as they could or check on them as carefully as they could. So it's important that the culture of the labs be sufficiently diligent to ensure compliance. So another idea to consider with respect to animal welfare and research noncompliance has to do with who are the people that are involved in evaluating when an issue comes up, when a problem arises. And I list some of these here because it can help with compliance. So first, there's the Ida Cook Committee, the Institutional Animal Care and Use Committee. This committee does a lot of heavy lifting in this area. They approve and oversee animal research protocols and do some initial review whenever there's an issue about whether a PI or a lab has failed to follow those protocols. There's also, again, the institutional officer and the RIO that we mentioned before. Again, the institutional officer has ultimate authority and will be expected to be communicating as necessary with outside agencies on these issues, so they need to know about them. And the RIO tends to be more heavily involved in the details of figuring out what the issues in a particular noncompliance situation were and what to do about them, and who should be addressing them. There are some other folks who can be involved as well. There can be veterinarians who might have more specific information about the animals under question, and it's important to have someone in that realm who can explain and identify issues about how animals have been cared for or not. And then there's the other facility staff within the lab, and often those are folks who might see the interpersonal dynamics between people in the lab or what the lab culture is like. So they can be sources of information about the human component of addressing scientific research in the lab. So those are important people to keep in mind. Another thought to consider with respect to, and this is really the last thought I'll talk about with respect to animal welfare and research noncompliance, is who needs to know outside the institution if something goes wrong? What are your reporting obligations? And for work that's funded by PHS, it's primarily going to be reporting obligations to OLA, and there's a serious description here of what the standard is for when you need to explain or report to OLA. That has to do with if you find there's a serious or continuing noncompliance or serious deviations from IACUC protocols, and any suspension by the IACUC of a protocol or of a PI. Those are issues that need to be reported, and it's best to report such issues early through the form of a preliminary report and as well as a final report once you know the outcome of the problem. It's important also to know that the USDA can come and inspect whether or not protocols are being followed, and that is intended to encourage transparent self-disclosure when any issue comes up. Another set of institutions to consider about reporting outside of your institution have to do with funding agencies, the grant funding agencies, particularly if noncompliance issues lead you to decide you need a change of PI to a different PI. Contractual documents with the grant funding agencies are likely to list obligations for reporting in those instances and maybe others. And so you need to check in the particular situation. When you're changing a PI because of issues that are under investigation but aren't concluded, it can lead to some challenging questions about explaining how deep to explain the reasons for what you're doing. And that can be a challenge. I don't want to sit here and say there's an easy answer to that, but there is some transparency that's important to think through, and that's why you want to have your team in place in advance so that you can address such issues. So with that, I mentioned I'd talk briefly about research noncompliance and animal welfare, and I want to talk more about research misconduct issues, which can be complex, and it's a different area with different rules, and it's important to understand how those rules apply. We have I list various sources of those, both from the regulations here in this slide, as well as a guidance document from ORI and the links here. In particular, the Office of Research Integrity Guidance is listed here, I think is a very helpful source of information for those new to a situation of research misconduct that want to understand how the process is supposed to work. I think it's essential to read that in advance if you're in an area of monitoring compliance or you might be subject to helping address a research misconduct issue, and I encourage you to read that. It helps provide quite a bit of information. So what do we mean about research misconduct? I'll talk a little bit what it is, but the concept and what's the goal and what is it that causes any issues that need to be addressed through research misconduct? It has to do with what the primary goal of scientific enterprise is. As the ORI has said, the primary goal of the scientific enterprise, which is the search for truth. And any form of research misconduct involves some type of activity that muddies the truth, that creates problems for the rest of the scientific community. And because funding for grants in these areas are very large and they're intended to advance the pursuit of truth, when that pursuit is impeded, it needs to be rectified in a much larger way than just addressing a particular PI, principal investigator, or a particular institution. When there's an issue, you need the community, the scientific community at large, to be able to understand that and to have that misconduct fixed, and so that they can rely on what is published and clear the record if necessary. So that's what creates a lot of issues in the research misconduct area and leads to questions and issues to address. So the questions I list here help explain what to do once misconduct is an issue and has become a question. And we'll go through these questions about who should be involved and what is the research misconduct, who determines if it occurred and how, and who needs to know. We'll go through that as we move forward. But before doing that, I think it's important to consider the risks that are involved in this area because they're unique and may impact pretty much everything you do in this area. So the risk factors listed here might be slightly oversimplified, but they're important to understand. So there's institutional reputational risk. Everyone within the institution will care if there's an issue of research misconduct that could be reported publicly. It's important to understand that. There's also individual reputational risks. And I list, it's possible there's more than one individual whose reputation is at risk because there may be multiple people in the lab that are implicated, not just the respondent. And it's important to know that you need to protect those reputational interests as best you can during the process of investigating. There are also obviously financial risks, both related to grant funding, potential refunds of grant funding, potential impact on future grant funding for the institution if there's a problem found. And there's also potential liability under the False Claims Act that we'll talk about more later that weighs on everyone. So those are big risks. And there's always the litigation risk that comes from employment issues relating to people who are subject to these investigations, whether it be defamation risk from the PI of some disclosure that they find untrue about the investigation, or from whistleblowers who may bring claims or feel like they were retaliated against for their involvement in raising these issues. So these are big risks to make sure you understand, and you cannot, though, allow these risks to allow you to detract from the pursuit of the truth and fixing the record in these areas. So the first question as far as thinking about research misconduct is who should be involved. The RIO is the main person, as I mentioned before. The institutional officer should also be involved. But then there are others here. There's an IT person. It's very important to secure evidence, digital evidence, computer evidence early on. I can't emphasize that enough. We'll talk more about this going forward. But it's not just the scientific evidence, but also the interaction evidence, so emails and other communications between members of the lab to figure out who did what and when. That's incredibly important to understand, and it's important to have an IT person around who can do that, who's knowledgeable. Then there are the inquiry and investigation committees that are required to look into research misconduct. They're comprised typically of faculty who are knowledgeable in some regard about the scientific area that's under review, and it's important to make sure that they are educated about how to conduct the investigation and the standards that they should apply. The inquiry committee is usually a shorter time commitment than the investigation committee, but in appointing people to those committees, that's important to keep in mind. There are also reporting parties that are involved with those committees, the potential whistleblowers and witnesses and lab members who have different interests and need to be considered along the way. So one overarching thought, though, in terms of who should be involved, has to do with carefully limiting the circle of informed people to preserve those reputational interests we were talking about. And one way of looking at that has to do with regulation about confidentiality in research misconduct, which states that disclosure of the identity of respondents in research misconduct proceedings is limited to the extent possible to those who need to know, consistent with a thorough, competent, objective, and fair research misconduct proceeding, and as allowed by law. So it really is a balancing act. You have to be thorough and careful. You want to make sure everyone who learns about these situations signs a confidentiality agreement and reemphasize the significance of that repeatedly, as well as having secure filing systems and protected drives for all data that's collected. Again, the RIO should lead that kind of effort and centralize that function. Another issue about who should be involved in research misconduct has to do with the need to sequester data. This has to be done right at the outset and should include all computers, hard drives, and scientific equipment that's used in the lab that could be relevant. Forensic analysis, in my experience, can become the most cornerstone element of the review. There's an amazing amount of resources that exist to evaluate adjustments in images of varying kinds that are used in scientific literature that often contain the misconduct itself. So it's important to make sure that you have a forensic expert that you can rely on in that area.
Pete,
Sure.
We actually have a question. So you've talked about confidentiality, not sharing the respondent's name with others, but also about needing to sequester data at the outset, which likely requires some communication with other members of the lab to know what equipment or other documents need to be preserved and reviewed. How can the interest of confidentiality and collecting all relevant evidence as quickly as possible be balanced?
Yeah, well, thank you for that. That's a challenge, and I think there's no one right way to balance those two interests other than the initial sequestering effort should be done without notifying anybody. That is, like securing the actual hard drives themselves or email accounts through the institution servers. All that should be done without notifying anyone to start as much as possible. And then once you've retained and maintained that evidence, then there's a need to ask and inform people within the lab that there is going to be a review and that you need to have certain materials that relate to the research in question, whether that be lab books or other computers, personal computers, other storage devices. So there's no one right way to do that, but it's important, I think, to apply a two-step process in that manner. So let's move on, if we could, then to the second question, an analytical question of research misconduct and what is it? And this slide lists the classic example of, it's referred to as FFP, fabrication, falsification, or plagiarism. And it may not seem as simple as what these definitions explain, but they have to do with making data up or recording it and reporting them, manipulating research materials, so changing what the results are or omitting data results such that it's not accurate. And then plagiarism is appropriation of others' ideas and processes without giving proper credit. But I think that's not that difficult to understand once you look into it, but it really is just the beginning. There's also a requirement that any form of those, fabrication, falsification, or plagiarism, be a significant departure from accepted practices. And that means that you have to understand the particular field at issue to understand if there's potential research misconduct, which means you need to have someone on your evaluative team that understands that field. It's important to understand that the burden of proof in this area is just the preponderance of the evidence, which means if it's more likely than not that there was research misconduct that was conducted. And again, it's not just issues of science. It's not just a question of whether the data was falsified or fabricated, but who did it. You have to tie it to particular people and their state of mind, which you list here and needs to be applied to each allegation if there are multiple allegations. But let's go over that in a little bit more detail. The state of mind has to be intentional, knowing, or reckless research misconduct. And intentional has to do with you intend to cause the result. You know that you're going to try to deceive the research community in a publication by publishing results that are intentionally not true. Then there's knowingly, which is where you're conscious, slightly reduced state, where you're of culpability, where you're consciously aware that conduct was practically certain to lead to falsification or fabrication, even though that was not the intent. So not careful enough, but you really knew that, consciously aware that that could happen. And then a third level is reckless. And reckless is a more vague standard, and it tends to be used less by institutions to find misconduct and is less prevalent in any ORI findings. But it has to do with where there's an independent basis for finding misconduct that doesn't require an intent to deceive. Instead, it's more akin to perhaps negligence plus. You're aware of a substantial risk that a negative result would occur as a result of your actions, and you deviate from what a reasonable person would do in applicable rules. So you're not certain that the result would occur, but you know there's a substantial risk. And that could have to do with a lab's culture that is not careful or with repeat examples of research misconduct that occur over time and thus demonstrate a level of recklessness. And it's important to keep those ideas in mind as we move forward. So the third area of thought has to do with who determines and how that research misconduct has occurred. So typically the RIO learns of allegations and assesses initially if it's potentially research misconduct or if it's just a mistake, and whether a further evaluation is needed. Then there are the faculty committees that get involved. I mentioned before there's an inquiry committee, an investigation committee. The inquiry really just decides whether or not there's enough information after an initial review of some information to think that there might be a problem. And the investigation committee does the full-on investigation. So they need to know the scientific background involved, but they also have to learn the other categories we talked about with respect to the state of mind to make sure that they're thinking about it. And in determining who and how, the sequestration of evidence is important and critical before the respondent can learn or delete anything within the chain of custody. That's incredibly important before the respondent learns. So another common question that comes up in this area of how do you determine if there's research misconduct is what do you do if the data is just missing that's supposed to support the published research, for example. And the regulations provide some answers here. They're a little vague, but they're answers. So the destruction, absence, or the respondent's failure to provide research records can be evidence of research misconduct, but it requires that they destroyed research records or they had an opportunity to maintain them but didn't, or they maintained them but didn't produce them, and, this is important, and a determination that such conduct is a significant departure from accepted practices in the relevant research community. So it's not just that it's missing, but it's missing in a way that indicates that people in that field wouldn't allow to happen. So that's part of the consideration. Another idea to keep in mind is who needs to know about research misconduct. This has to do with reporting obligations. The Office of Research Integrity is the most significant reporting entity that needs to be considered. You do so at the inquiry stage when it's moving into the investigation stage. So if an inquiry determines there's no suggestion of any research misconduct, and that's the end of it, there's no need to report to ORI. But if you move on to the investigation stage, there would be. And it's important to know, I've learned over the last several years, ORI can be very helpful with the process. They can help you with forensic evaluation techniques. They can help with just understanding, and the investigation committee who will be new to this, understanding what their role is and what they should really be looking for. And eventually, any review that gets prepared through the investigation committee will be shared with the Office of Research Integrity. And that obviously affects everything along the way in terms of knowing that it's going to be reported to a federal agency. Another issue to think about in terms of who needs to know, which is slightly unrelated and a little new, has to do with reporting any kind of False Claims Act issues. Now, False Claims Act issues are different, and the question is, when do you have to self-disclose? The issue there has to do more with the materiality of the misconduct to obtaining grant funding. Was there a fabricated or falsified data in a grant application that led a grant funding agency to fund? And if that's the case, then there are various enforcement entities that are going to be interested in learning about that. Sometimes in the course of research misconduct investigations, you learn of fabricated or falsified data that was published and then later used in grant applications. And the question has to do with, do you need to self-disclose along the way? The Office of Inspector General and some of the grant funding agencies have recently sought to implore institutions to self-disclose early, and that can be a challenge, frankly, and it requires some real careful analysis about whether to do that.
Pete, we have a question related to this materiality concept that you just talked about. So with respect to materiality that applies to the False Claims Act and then the potential self-disclosure to the OIG, who should determine whether misconduct is material to a grant funding decision? Should it involve people who are not engaged with the misconduct analysis itself? Do you have any thoughts on that?
Yeah, that's a really good question, and I think that there are distinct questions. Research misconduct can exist without it being material to grant funding, and it's important that the Research Misconduct Investigation Committee focus on their task. Their task is to understand whether research misconduct has occurred. So we tend not to advise them to weigh in on the materiality question as to whether the falsified data was so significant that it was material to a funding decision. Instead, you usually want to have a group of people, whether it's the RIO along with a couple others, to do some independent review of the materiality of any falsified data that was used, for example, to obtain grant funding. So that can be a challenge to do. It can feel expensive and like a whole nother review, but I think it's important to distance the investigation committee from evaluating materiality because it can lead to issues with how they're assessing their main goal, which is the research misconduct issues. So, with those issues in mind, I know we're trying to move through things here relatively quickly, and I see we're right at about our time spot. Here's some sort of wrap-ups about research misconduct that I think about. And that is, it's important to prepare in advance and to really understand your policy before a case comes in. Understand if there are allegations that each case is different. They may expand. They may turn out to be something that's easily explained. It's important to really be careful on how they're all evaluated. Forensics, I keep saying this, are the key both at the outset and along the way. So it's important to try to, if you can, have a forensic expert at the ready to know about them before you get a matter that you have to deal with. And then the last thing is that educating the faculty committees about the process and evidentiary standards is something you have to be ready to do and to do repeatedly so that they can do their job. They learn really quickly, but their knowledge is mostly about science and less about investigative techniques or the regulatory requirements of a research misconduct investigation. So it's important to make sure you explain such things to them. So as I mentioned, I see we're here at the end of the hour, and I know we've had some questions along the way. I see that we have some other questions that have come in, and we will do our best. We'll make sure to get back to those questions independently of the webinar. But I want to just thank everyone for joining our program today. We hope the information provided was helpful to you and your organization. If you haven't already, we ask that you please click on the survey icon at the bottom of your screen to complete our short survey. Please do that. Your feedback assists us in providing even more quality future programs, so we really appreciate that. As a reminder, this program has been approved for continuing legal education credit in the following states: in Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. So please get that credit. A recording of the webcast will be available tomorrow for watching and for sharing. And once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording, we should note, will be available for 2 weeks. So if you're interested in that, it's best to listen to it sooner rather than later. So this concludes our webinar, and on behalf of Wakaba and our other partners here at Husch Blackwell, we want to thank you for joining us and wish you a good day. Thank you.